where the court will not collect that. I believe White Pine County, they asked that NDOW do that themselves, but yes, the procedure is for that to be part of the charging document.
So that would then, part of the criminal process, the state would ask for the court to impose a civil penalty as part of the conviction, in addition to any criminal penalty. That's left then to the judge to decide. In contrast, the assessment of the demerit points would be something that NDOW does on its own.
Exactly. A judge doesn't have purview over the demerit system. It's something that the statute says that NDOW's in charge of, and obviously there are appeal rights as we're dealing with today, that this commission can see that it's enforcing those rights correctly, but it's not something that the judge would do during a criminal case.
Thank you.
Further questions from the commission for Mr. Woodbury? Thank you, sir. The next, Mr. Woodbury.
Thank you. There are only two things at issue in this case. That is whether or not Mr. Bennett was convicted of under NRS 503.030. And you can put all the numbers you want in there, but under the statute, NRS 503.030 is a gross misdemeanor. And Mr. Bennett pled guilty to a misdemeanor. Therefore, you might say that when it says in his plea agreement that he is going to plead guilty to 501.185, he probably did. And the fact that the state of Nevada, through the Yoko County District Attorney's Office, put other stuff in there is irrelevant. The fact is that you can't just magically snap your fingers and change a gross misdemeanor to a misdemeanor without going through the proper procedure. He did not get convicted of 503.030 because that's a gross misdemeanor and he wouldn't have pled guilty to it.
Mr. Woodbury, I have a question. Where do you find, what supports your position that a violation of NRS 503.030 is a gross misdemeanor?
It's in the statute.
Which statute?
I'd have no idea.
I'm reading NRS 503.030.
Right.
And there is no penalty provided for possession of wildlife after the end of the open season.
Right.
So if that statute does not provide what the penalty is or classify it as a felony or any particular felony or a gross misdemeanor or a misdemeanor, then doesn't it fall back that it is a violation of Title 42 and therefore would be treated as a misdemeanor under NRS 501.385?
Gee, no.
Why not?
Because there's specific statute that says it's treated as a gross misdemeanor.
But that's a different statute.
Okay.
501.376 subsection 4 is a gross misdemeanor that says a person shall not willfully possess any animal killed outside of the prescribed season if the person knows. It's a different crime. That has different elements. 501.376, the gross misdemeanor, requires the state to prove that they willfully possess the animal with certain knowledge. The charge of 503.030 does not have those additional elements, and without those additional elements, it seems like it would then fall into the misdemeanor classification.
Oh, clearly you're right. Clearly Mr. Bennett should have been convicted of a misdemeanor under 501.030. That's nonsense. I'm telling you the statutory scheme is otherwise. You have legal counsel if you want to
Ask you questions as the person who's hearing this. And you're saying he pled guilty to a misdemeanor.
I'm not saying it, it's in your stuff.
Okay. In the packet, I have a memorandum of plea agreement, and he did, in fact, plead guilty to a misdemeanor, NRS 501.385. And when I look at that statute, that says a violation of Title 42 is a misdemeanor. What was the violation? It was the unlawful possession of a mammal outside the season. So The crime was 503030. The penalty was the misdemeanor in 501385.
Part of your problem is that it is a fairly subtle proposition of what possession and control is.
But I'm
If you're
not.
going to talk to me, you're going to have to give me a
Okay.
chance to talk to you.
Well, answer my question then.
All right? That's the problem. You have a statute that talks about what possession and control is. Then you have case law that talks about what possession and control is. Then you have a criminal complaint that tells you the circumstances under which Mr. Bennett did the act that is so horrendous. He did not have possession within the meaning of the law. He did not have control.
Wait, now you're arguing that he didn't, actually is not guilty of the crime to which he pled no contest, the legal effect of which is a guilty plea and a conviction. So let's not argue about what possession is or not. You told me this decision is legal. What did he plead guilty to? We can base it on the documents,
He pled guilty to what he plea bargained to plead guilty to.
which was a violation of 503030,
Baloney.
which was charged as a misdemeanor.
Look at the plea agreement.
I am.
What does it say he's pleading guilty to?
Possession of wildlife outside of open
What
season.
statute is cited?
The misdemeanor statute 501385. That's the penalty, not the actual offense.
All right. So you have other questions I haven't answered?
Did you draft the plea agreement? Or did the DA?
Not a bit. You ask your attorney, he's sitting right there, and he will tell you that every ambiguity in a plea agreement between the state of Nevada and a criminal defendant, every ambiguity is construed against the state of Nevada.
And when
So it
it's,
doesn't make any difference whether
well, I don't think it's ambiguous. I think it's quite clear that the state agreed not to seek civil penalties.
Yeah.
That would simply be a reference to the civil penalties that are provided for in NRS 5013855,
Yeah.
and would have nothing to do with the assessment of demerits. There's not a mention of demerits being assessed in this plea agreement at all.
Yeah.
Would you agree with that?
No, I think civil penalties are demerit.
But there's two different statutes. One statute talks about that the commission, and the language is quite clear, shall establish and the department shall administer a demerit system. That's NRS 501-1814. An entirely different statute addresses civil penalties for wildlife convictions under 5013855. So when you say in this plea agreement the state further agrees to seek no civil penalties, then that is a reference specifically to civil penalties. It has nothing to do with demerits. That's a separate issue.
So you have decided that I'm the guy that drafted the agreement?
No,
Oh, okay.
I'm saying the plea agreement itself only references civil penalties, which be referenced to one statute, not both.
Did you happen to notice that in the plea agreement, the word civil penalties isn't capitalized like it is in the statute?
I do see that.
Did you happen to notice that there is no citation to a statute including civil penalties?
I did see that.
Okay. And did you have to notice that there are no quotation marks around civil penalties?
Yes, and I also notice it does not say the state will not assess demerit points as a result of this conviction. That is tellingly absent from this plea agreement.
And so what we're saying, and you can do whatever you want with it, the word civil penalties doesn't necessarily just include the word civil penalties in the statute. Civil penalties have some very broad meanings, and a civil penalty means a penalty. Your attorney will no doubt write you something along that line. A civil penalty is differentiated from a criminal penalty by who imposes it, and the Nevada Division of NDOW imposing it makes it a civil proceeding, and the fact that their demerits are a penalty make it a civil penalty. And if it's ambiguous, again, let me take you back again. I assume that your attorney will at some point say to you, any ambiguity in a plea agreement is resolved against the state. Okay?
Well, I have another question. It was, though, the amended second criminal complaint against Mr. Bennett that was the charging document to which he pled no contest.
Yeah.
Yes?
Yeah. But you will also notice that he submitted at the time of the hearing, it was explained to the court that he was pleading guilty pursuant to a case called
Alford?
Alford.
I understand.
And that has to do with the proposition that sometimes in order to avoid the possibility of a larger punishment, you plead to a smaller one even though you don't think you're guilty of the crime. I don't think that has anything to do with us, what we're doing here today, but I want you to understand that.
Well, I do understand that, I appreciate that, but the legal effect is still a conviction of the crime charged.
Right.
And all the consequences that flow from that conviction, whether it's Alford, no contest, or guilty, that's the result.
You got it.
And Alford also stands for the proposition that people don't admit that they're guilty, but admit that the state could prove a crime more serious than when they're pleading to beyond reasonable doubt. And they don't want to face that possibility, so they take a deal.
So long as you differentiate between possibility and could do it. All right, as I understand Mr. Stockton, what he's saying, in my mind, makes a lot of sense. He's going to, we have on 2 occasions, Mr. Woodbury and I, and Mr. Stockton, with a copy of the letter I wrote to Mr. Woodbury, have communicated. Both of them have written letters to me. Despite content of what has been said back and forth here today, there are 2 very specific legal questions. And I think Mr. Stockton is going to write a document and somehow communicate it to me and Mr. Woodbury that what his conclusions are. And that, again, it's only about the ambiguity in the plea agreement, and it's only about the complaint that essentially alleges, in our view, a violation of 185, not 430. And when he does that, I will be more than glad, I probably already should have, but I would be more than glad to respond with case citations and a regular brief to it, so that, and I'm sure Mr. Woodbury will do as well. And then he can give you the recommendation, or perhaps not a recommendation, he can advise you whether what I'm saying is nonsense or whether it has some possibility of being true. And then I'm assuming you're making a decision, and I want you to note that that's essentially what I suggested when I wrote in the response to the direction that I come down here today, that it is a lot simpler. And again, despite the apparent legal argument between Mr. Johnson and I, there are a couple of fairly subtle legal issues that I'm sure Mrs. Stockton and Mr. Woodbury and possibly me will be able to resolve.
Mr. Woodbury.
Just a couple of points to clarify. One, I think part of the question of whether a violation of 503.030 is a misdemeanor or a gross misdemeanor has been brought up by Mr. Bennett, but or excuse me, by Commissioner Johnston. Initially, Mr. Bennett was charged with both a violation of 503.030 and 501.376. And as was pointed out, 501.376 is a gross misdemeanor. It has its own unique set of facts. It's its own crime that can be charged. And that, under that section, along with the elements, it does provide that it's a gross misdemeanor. 503.030, unlawful possession, which is the one that he was eventually pled no contest to, does not contain that penalty element. It doesn't state that it's a gross misdemeanor. There is no place in statute that identifies that as a gross misdemeanor. We do go back to the 501.385, which is a misdemeanor. The state dropped the charge of 501.376 and eventually accepted the no contest plea on just the 503.030. So I think some of the confusion of whether that statute can be a misdemeanor or gross misdemeanor is based on the fact that previously there were 2 counts charged and just one of those was pled to, the one being a simple misdemeanor, not a gross misdemeanor. So that's the first point, that nowhere in statute does that require or identify 503-030 as a gross misdemeanor. The second one refers to civil penalties. The definition of civil penalties, again, is very simply stated in the statute of what a civil penalty is. It's a monetary penalty. But above and beyond that, when we get into the definition of the demerit system, in 501.1814, it says, the commission shall establish and the department shall administer and enforce a system of assessing demerit points for wildlife convictions. Again, that puts the demerit point process outside the scope of the courts. It's not a criminal violation that would be in front of the courts. The court has no jurisdiction to say whether demerit points should or should not be assessed. The district attorney doesn't have the authority to enter into a plea agreement that the demerit points shouldn't be assessed. It's under the purview of the commission establishing and the department administering. Once there is a conviction, a wildlife conviction, that goes into the hands of NDOW and subject to NRS 501.1814. They use their processes has been outlined in statute. And so the argument we would put there is not only is this not a civil penalty, but it's not something under the purview of the courts in the first instance. And that's all I have.
Thank you, Mr. Woodbury. Mr. Stockton, I have a question.
So for the record, Brian Stockton, Senior Deputy Attorney General. And just before we start, I'd like to correct one thing Mr. Gary Woodbury said, is that whatever I write up will be what you tell me, and not my opinion. Because I represent the board, whatever decision comes out has to be your decision and not mine. So with that, please.
That was part of what I wanted to clarify, and at this point is we bring it back to the commission for, just procedurally, I just want to make sure we're going the right direction.
Correct. So,
Okay.
and that probably at this point would be a good place to take the public comment if there is any, which I hope there's not, but remember to not really take into account public opinion in making the decisions.
Okay, thank you, Mr. Stockton, and I will take this opportunity to ask for public comment. And seeing none, I'll bring it back to the commission for discussion and decision. Commissioner Johnston.
I guess I'll start the discussion. I've been through this, spent a lot of time going through all the materials that provided us on this appeal to get an understanding. I'd like to say to Mr. Gary Woodbury, I think you did, Mr. Bennett, you served him very, very well in the proceedings that were pending out in Elko County in the Justice Court as his counsel, and getting him the deal that you got him, given it started off as a felony charge. But now we're here with the conviction, and the issue is, did the department rightfully assess the 12 demerit points? And as I understand this, what the department did was viewed the conviction as a conviction based upon a plea of no contest to NRS 503.030, which under the administrative code required an assessment of 12 demerit points. The question then is that what he pled guilty to? And I have to answer that question in the affirmative. First of all, the charging document, which is the amended second criminal complaint, charged possession of wildlife at a prohibited period of time as defined by NRS 501.385 and NRS 503.030. The crime was the violation of NRS 503.030. The penalty was a misdemeanor, which is the catch-all statute in 501.385 that says a violation of this title unless prescribed otherwise is a misdemeanor. So that was the charging document. The plea agreement specifically says that he is entering a plea of no contest to one count of possession while outside of open season, a misdemeanor in violation of NRS 501385. That just relates to this being a misdemeanor crime. But the plea agreement obviously states on its face, clearly and unambiguously, that Mr. Bennett was pleading guilty to the possession of wildlife outside of an open season. That statement, that crime, is not set forth in 501385. So on its face, the plea agreement makes clear that it's pleading to a misdemeanor, and that because that is what the district attorney agreed to charge. So I think the state, based upon that plea agreement, rightfully assessed the 12 demerit points. And the question is, did the state somehow, was the department precluded from assessing the 12 demerit points, given the fact that the plea agreement said the state further agrees to seek no civil penalties against me regarding those events? I don't find that language is ambiguous in any way. It says the state will not seek civil penalties. There are two statutory schemes, one for civil penalties and one for the assessment of demerits. To obtain civil penalties against a criminal defendant, the state would have to seek them. They'd have to ask the court to assess them. That language in that seek no civil penalties is clear that the state agreed not to ask the court to assess a civil penalty on behalf of Mr. Bennett, which in this case, I actually think it could have been classified as a trophy mammal, because I believe it was a 6x6 bowl. It could have been a $5,000 to $30,000 fine for civil penalty. That was not assessed. Nothing in this plea agreement says that the state shall not impose demerits based upon this conviction, and I think that's a very important omission from this plea agreement. In addition, part of our record is the transcripts of sentencing, in which there was no reference whatsoever to the demerit points. Counsel for Mr. Bennett went through that, yes, there was an amended second complaint. There was reference to the plea agreement. And it said, this was counsel for Mr. Bennett, Mr. Woodbury. Mr. Bennett is going to be pleading guilty, pleading no contest to the amended second criminal complaint under the Alford case, and the state and the defendant stipulate to a fine of $250. I have no, then the transcript says inaudible, and Mr. Woodbury says, and no fees. And he authorized you to enter that plea on his behalf? Yes. That's because Mr. Bennett was not present. The deputy district attorney then said, I think what Mr. Woodbury is talking about, no fees, the plea agreement states that we are not seeking any civil penalties. Mr. Woodbury, oh yeah. The court, obviously there would be the court imposed fees. Mr. Thompson, court fees. I don't think you can stop that. Goes through. There was no discussion whatsoever at the time of sentencing that this plea agreement would have precluded the state from imposing demerit points. It was strictly related to monetary fines, and they noted that they could not avoid the mandatory fees and assessments that the court has to pose upon a conviction. And then when we get the memorandum of sentencing, it follows still possession of wildlife outside of open season. That memorandum of sentencing, which is part of the record, confirms that that in fact is what Mr. Bennett pled no contest to, which would then be the violation of NRS 503030. So when I go through all that, I just don't see any error that the department made in assessing the 12 demerit points as set forth in the Nevada Administrative Code and revoking Mr. Bennett's license for 3 years.
Thank you, Vice Chairman Johnston. And I do agree with what you've said. You did your homework on it and know what to look for and discuss, and I do agree with you. And I want to get further commission comments or discussion on it. Is there anything? Commissioner Hubbs.
Yes, I had a couple comments. I agree in the final result with Brad, or Vice Chair Johnston. But when I was looking over this, I saw it a little bit differently. And I just wanted to talk about that. When I look at the plea agreement, obviously we look at the four corners of the document only, and it looks like there is a misdemeanor pled for violation of NRS 501.385. That statute is different than the one that was used by the department when they issued the notice of the demerits. They referenced another statute. My only concern with that is on the plea agreement itself, the next paragraph specifically states that any other charges that were pending against Mr. Bennett were dismissed. So, in my opinion, everything outside of 501.385 were dismissed when this agreement was signed. But in and apart from that, he did sign to the misdemeanor to this violation. And I'm just wondering, I do not believe that the civil penalty reference speaks to demerit points. I think that's separate and apart. It's not included in the agreement. And as far as we want to expand on that, I think that that's pulling it too far. It's not mentioned. And so I believe, that being said, perhaps the only issue that I have concern with is that the fine for demerit should be based on the actual statute in which Mr. Bennett pled to.
Thank you, Commissioner Hubbs. Further commission comments, questions? Your light's on, Commissioner Johnston. Do you have something?
I guess I don't want to continue to go over the same thing, but I'm looking at the statute now, and in particular NRS 501.385, which is the statute that's referenced in the plea agreement. And that statute says any person who performs an act or attempts to perform an act made unlawful or prohibited by a provision of this title is guilty of a misdemeanor. That's subsection A. Subsection B is willfully fails to perform an act required of the person by provision of this title is guilty of a misdemeanor. Subsection C talks about obstructing, hindering, or delaying or otherwise interfering with any officer. And then there are other provisions. Given that this plea agreement specifically says he's pleading no contest to one count of possession of wildlife outside of the open season, the reference in the plea agreement to NRS 501.385 is simply to confirm that charge was a misdemeanor charge, but the violation that occurred would have been the violation of 503.030 as set forth in the second amended criminal complaint. When someone is arraigned, there is a document. This is the charge against you. And we know what that charge was from the amended second criminal complaint. And it was to that crime that Mr. Bennett was charged that he entered the plea of no contest. He can't change that by way of his plea agreement and say, I didn't plead no contest to a violation of 503.030 when that was the charging document to which he entered his plea. So there's no, in my mind, there's just no question that that was what this plea deal was, and that the district attorney charged it as a misdemeanor. But whether it's a misdemeanor or whatever it is, the demerits are set forth in the administrative code as 12, so that the State Department did not err in assessing those demerit points on Mr. Bennett.
Commissioner Hubbs.
So I guess I just have a question. So as to the demerit points and I was wondering if there are any deviations between demerit points for NRS violations of NRS 501.385 and 503.030.
Depends on the violation.
Just to make it clear, I should probably address that. So in NAC 501.200, it talks about the list of demerit points. And as Mr. Joshua Woodbury pointed out, there's a description of the violation, and it does list a statute section number. And there are differentiations in there However, the ones listed for 501.0 or 385 don't match what the conviction was here. So that's the disconnect.